Page wise adjournments. Serial number 90. Page number 5. Serial number 90. 20 to 30.
At the request made by the council, thank for the response number 3. Just after 2 weeks. 20. By Leonard just after 2 weeks.
About 31 to 36.
Yes. 35. Request by the petitioner list after 2 weeks. Granted earlier exception. 30? 38. What is this? Okay. Who? 2 weeks. 2 weeks. 30? 33. Oh. Just after 2 weeks.
At 46. Well, at 46.
45 this next week.
46, my lord.
Yes,
I have
sir.
filed Wakalat Somshekhar. I have filed Wakalat for taking DK Sriramappa, my lord.
Yes.
For R2. I have spoken to, requested Mr. Jaiprakash Reddy, he has agreed. It can be called on 16/11, my lord.
Somshekhar has filed power on behalf of the respondent number 2.
On second, I have filed.
So, registry is directed to verify the same and print the name of Sri Somshekhar and a council appearing for the respondent number 2 by deleting the name of Sri DK Sriram and a council appearing for the respondent number 2 from the card list.
Kindly have it on 16th, my lord, because Jaiprakash Reddy wants it on 16th. Last package.
16. Very well.
Much obliged. Much obliged. 55. List after 2 weeks. As paid by the council appearing for the petition.
Serial number 56, my lord.
Yes, sir.
I pray for a week's time, my lord. Senior has undergone gallbladder surgery, my lord. I pray for a week's time, my lord. 56.
56 at the request made by the council appearing for the petitioner. List after 2 weeks.
Much or
the second respondent.
55. 55. Okay. Your name has to be. Your name has to be shown. 56.1. Registry is directed to print the name of Mr. So-and-so appearing for the central government. Yes.
And I appear for the second respondent.
Yes.
62
After 2 weeks. After 2 weeks. 56. 21st. 40 for the petitioner. Just after 2 weeks.
167. Serial number 70 and 72. Serial number 1.
New of the fact, the elevation of Honorable Justice Sri Nataraj or to the bench of this court. The registry is directed to delete the name from the file list. Who is appearing? Issue court notice to the petitioners. Yes, sir. Interim order, if any, extended till next of year. Which one, sir? Yes, sir. R3, who is appearing for R? Who is? Yes. Infractures. It is submitted by the Lana Council appearing by the petitioner that the prayer made in the writ petition has become infractious. Accordingly, petitioner disposed of has become infractious. 2 weeks time is granted to take necessary steps for unserved respondent. What is this matter? Yes, sir. Padikodi. By FCL, Padikodi. What your challenge? Where is the impugned order? Where is the impugned order? Annexure? Page number 69. Order dated? Dated 4/4/16 is challenge, sir. 4/4/16. Just go to 4/4/16. Yes, recall the order and permit the respondent just cross-examine. Who has to cross-examine? Let there be a law. Sorry. Sorry. This petition is filed by the petitioner challenging petitioner. This petition just filed by the respondent. Filed by the respondent in MC number 2777 of 2013. On the file of the Principal Family Court at Bangalore, challenging the order dated 4/4/2016. Heard the Lana Council appearing for the parties. The respondent herein has filed petition seeking dissolution of the marriage, and in the said proceedings, the family court by order dated 4/4/2016, rejected the prayer made by the petition herein to cross-examine the PW1 dash respondent hearing. Having taken note of the factual aspects on record and the factual aspects on record, I am of the view that the order dated 4/4/2016 is liable to be set aside by imposing cost of ₹5,000 to be payable by the by the petition hearing to the respondent, comma, and the petition and the respondent hearing shall present before the, when will be the next date of the respondent hearing shall present before the family court on the next day of hearing without fail, and the petition hearing shall pay the cost and cross-examine the respondent hearing in view of the fact that the petition is pending consideration before the family court for more than 9 years. It is also made clear that the family court shall expedite the hearing and dispose of the entire proceedings within 6 months from the receipt of this order. No. The requirement cost to 3,000. Instead of 5,000, 3,000. Yes. Steps to be taken in 2 weeks. It is submitted. You are on record. Nothing. It is list of prayer made in the writ petition has become infructuous. Accordingly, writ petition is disposed of as having been. Or when a counsel appearing for the respondent number 3 seeks 1 week's time to comply with the office. State is not a party as respondent number 3 in the petition. Amended, when a counsel appearing for the petition submitted the amended cost title is furnished. Registry is directed to verify the submission with regard to not making the state as a respondent is accepted. Accordingly, office objection number 2 is overruled. What about R2 service? Yes, sir. What about R2 service? State diploma nursing examination board. Why R2 only? Why it is service to R2 is included? The college association. Who appears for the college? You send him. Pass on to him. Is it? Yes, sir. Supplementary examination. David, you thought you can do it. Yes. Of course, in the operative portion, it should be November instead of June. Yeah, but they have to make arrangement for that. When you are going to third will not council appearing for the parties. Third will not council appearing for the parties. Having taken note of the grievance made by the petitioner college in the writ petition, I'm of the view that the relief sought for by the petitioner herein is covered by the order dated 13th June 2022 in WP number 449 of 2022 by this court. Taking into consideration the fact that there is a requirement of announcing a result of the students who have taken examination, and if any of them have been failed, and they have to appear in the supplementary examination being conducted in the month of November 2022, petitioner hearing is directed to announce. You have to announce the result. Announce the result of the students and permit those students who have failed to take up the balance paper in supplementary examination upon payment of examination. Full stop. It's also made clear that the petitioner college shall forward the which examination practical marks of the students forfeit to enable the respondent to enable the second respondent to take further action in terms of the order dated 13 June 2022 in WP number 4. Writ petition is disposed. Yes, sir. To whom? Now it has to be allowed. Which is that application? Just a first one. Amended petition. Order sheet. Taking into consideration the governments made in the application accompanying affidavit, IA number. Which is this IS? The application filed by the petitioner seeking amendment is allowed. It is submitted by the Lana Council appearing for the petition. Notice to the respective students be dispensed. The same is accepted at the risk of the petition. Yes. Yes. Quashing the ordinance dated 29/3/2019. Ordinance. Yes, sir. Requires a hearing or? Yes, correct. If it is required hearing afternoon, I will. Yeah. Who has to answer? R3. I think here, yes. When at the earliest, Next Monday, without fail. Without fail, next Monday. Even so, is your brother? No, ask him. Yes, sir. 2:30 next Monday. 2:30 next Monday. There is he. Yes, next Monday. Yes. Yes, sir. Await service in this R2. Sorry, it is. So colleges apply for which course? MCA. MCA. Correct. Yes. So it has to be ratified by the state. Yes, sir. Yes. Yes, sir. Yes. $63, sir. Yes. Approval has been. Yes, sir. Correct, sir. Intake 2022 is. Yes, 60. Some aspects is. What's the state government did? $73. Is it? So yes, this is by the university. 76. So intake 60 is accepted. Where? Yes, sir. Additional course combination. Correct. That means whatever you sought is accepted. Now it has to be ratified by the government. Syndicate. $84. 108. Dr. Narayan Swami. Yes. It's not to recommend an intake of 40. 60. So in fact, LIC has recommended 60. Yes. No, of course, prima facie is not correct. Just 1 minute. Yes. Why you have taken the 20? Huh. Where is that 25/6/22 order? No, but you say that recommended for 20 seats. For how many seats? The grant of AACT was post syndicate. Post syndicate. Can you reconsider it now? So decision of the AACT was not well within your knowledge. In the event, take for an example, in the event if the AACT, yes, ma'am? University. In the event if the university says take intake of 60. Independently you can take decision. But what has happened, so for the university is concerned, see, order of the ACT was 7/7/22. By that, the syndicate had already taken a decision. Do one thing, let they will reconsider it. That's one. But only he has to say 20th of this month. Oh. So already you have taken students. 40 is that now what is approved, but even by the government is 40. Syndicate has to take a decision. Put in University Act, Karnataka State University. 59(2) says just let us see 59(11). 1 minute. 59(11). 1 minute. The state command shall consider. That means the state government role is only after university would take a decision. Decision from the university. You take the decision just in the within how many days you take? Within how just a minute. Within how many days you can take? Because 20th, as he pointed out. Yes, sir. No, but you reconsider it, take earlier decision. $59. Yes, correct. 60. Oh, no, it's not like that. See, ultimately the solution. No. Ultimately the solution. No. Ultimately you have to take decision better. I will dispose of. Yes. 120. 115. Yes, sir. By the government, sir. Also, let them reconsider, but in a time frame that they have to do. Let us now from how many days you take decision? Page of the government. Yes, sir. Intake sort is 60.
In my presence, when it is found in my college, the government does
Oh. But if you look at annexure G, university, they say that's 60. How it has come 20? Within how many days that you can take this? That, but you have to take decision in the matter. Whether the interim order was granted. Of course, LICS say that you take 60. Then how can you say that 20? Either page number 12 of the statement is incorrect or the report is incorrect. But it cannot be because it's issued by the very same person. Yes. Only thing is interim order I can consider. That we will see. Interim order will say you take a letter, they will take a but he has to say, that's what I'm saying. I want to dispose of. Let you the event if say that within how many days you take. But 20th is the that should be 20th is the last date for date of examination. Anyway, all so and entire exercise should be done within before 19. 30. In fact. I know. No, they will do it. Positive. Be positive. Please sit down. Good. Petitioner, please sit down. The petitioner institution is approved by the second respondent, comma, and recognized by the first respondent, and the first and the petition institution is affiliated to the third respondent university. The grievance of the petitioner that the petitioner had made an application for comma made an application to the respondent comma seeking grant of a new MCA course with an intake of 60 students for the academic year 2022-23. The respondent number 2 for the approval process through its scrutiny committee prepared an application deficiency report wherein the petition institution was examined on various dates, and thereafter, the report dated 26/5/22 was made as per Annexure C to the petition. It is the case of the petitioner that the second respondent hearing by order dated 7th July 2022, approved for intake of 60 students for the academic year 2022-23, and thereafter, the third respondent university, sent LIC committee to look into the infrastructure and structure, facilities provided by the university, and accordingly the said LIC committee by Annexure G to the writ petition, as recommended for 60 seats, 60 intake of 60 students for MCA for the academic year 22-23. Thereafter, the said LIC committee was placed before the syndicate, and the syndicate, as per order dated, and the university, taking into consideration the decision taken in the syndicate by letter dated 7/7/2022, in bracket Annexure J to the petition, as recommended an intake of 40 to MCA course, and taking into consideration that the LIC has recommended only 20 seats. Based on the said aspect, the government had taken decision on 7/9/2022 as per Annexure K to the writ petition, and allotted intake of 40 students to MCA for the academic year 22-23. Feeling aggrieved by not allotting the entire seat of 60 intake of 60 students, the petition institution has presented this petition. I heard Mr. So-and-so Shiva Prasad on behalf of Mr. So-and-so for the petitioner, and Madam So-and-so for the Leonard AGA for the government, Mr. Pramod for respondent number 3. Respondent number 3. What about 2, sir? Could be discussed. Order sheet. Notice, Learner Council appearing for the petitioner submitted that notice to the petition number, respondent number 2 be dispensed with at the risk of the petition same is accepted. See, Shiva Prasad, Learner Council appearing for the petitioner, invited the attention of the court to the LIC committee report produced at Annexure G to the writ petition, and argued that the remarks made by the committee was to take intake for intake of 60 students. However, the syndicate of the third respondent hearing, has misconstrued the same as per the item number 7 of the resolution dated resolution dated 27/6 27/6/2022 within bracket annexure J to the writ petition argued that there is no reasons have been stated by the university refusing to exceed for intake of 60 students and accordingly sought for interference of this. Madam so and so had submitted by reiterating the averments made in the statement of objection and invited the attention of the court to the annexure R1 to the writ petition, annexure R1 to the statement of objection, and stated that the recommendation made by the syndicate of the university has been taken into consideration and same has been considered by the government in terms of section 5911 of the Karnataka State University Act 2000. She promote Lana Council appealing for the third respondent university, argued that by the time the university had taken a decision in respect of the allotment of total seats to the petition college, the universities did not have the benefit of the approval order dated 7/7/2022 by the All India Council for Technical Education produced at annexure E to the writ petition, and therefore he submitted that there is no infirmity in allotting the seat by the university. Having taken note of the arguments advanced by the council appealing for the parties, I carefully examined the letter dated 7, which is that ACTE date, annexure A dated, annexure 63, sir. Yes. Dated 7/7/2022, whereby the technical education, All India Council for Technical Education, having taken note of the factual aspects on record, has approved intake of 60 students for academic year 2022-23 within bracket annexure E to the writ petition. In the light of the said recommendation, I have carefully examined the LIC committee report produced at annexure G, whereby it is unequivocally, the LIC had come to a conclusion for allotment of intake of 60 students to the academic year 22 and 23. However, the said aspect has not been properly considered by the syndicate while taking decision on 27/6/2022 as produced at annexure J to the writ petition, full stop. The item number 7, in item number 7, serial number 5 of item number 7. Serial number 5 of item number 7 is pertaining to the petition institution where the syndicate, where the decision of the syndicate reads as under page 108. Though the Lana Council appealing for the respondent university, pointed out that the decision of the university was taken in the absence of the approval process made by the AICTE on 7/7/2022. However, taking into consideration the factual aspect that the LIC committee of the respondent university has recommended for 60 seats for the academic year 22-23, however, the aforementioned remarks in the remarks by the syndicate would indicate that LIC has recommended only 20 seats, which according to me is not correct, and the recommendation made by the university for intake of 42 MCA course for the petition institution is in the absence of is without looking into the LIC committee, and therefore I'm of the view that in terms of section 59 clause 11 of the act, where the state government ultimately has to take decision in the matter based on the recommendation of the LIC committee, local inquiry committee, academic council and syndicate of the university. I'm here with direct the third respondent university to take decision at the earliest and send the report to the government to take appropriate decision in accordance with law, taking into account the recommendation made by the AICTE produced at Annexure E to the writ petition, as well as the LIC committee report produced at Annexure G by the respondent university. So it's also made clear that both the government and the third respondent university shall take decision in the matter within today 6th 1 week andru take decision within 1 week from today. That is it. No, nothing. Take within 1 week from today. But shall take decision in the matter within 1 week from today, taking into consideration the urgency pleaded by the Lana Council appealing for the petitioner that the date of next date of examination for the MCA course will commence from 20th November 2022. It is also made clear that the university shall take decision in the matter as far as at the earliest, taking it and thereafter send the report to the government for taking appropriate decision in the matter. In the result, the writ petition is allowed, return. Which order has to go? Annexure. Annexure K is the university, sir. Annexure K dated 7/9/2022 by the state government, and which is that government syndicate, and the decision taken by the syndicate of the third respondent herein dated 27/6/2022 within bracket annexure J close the bracket to the petition is passed insofar as the petition institution is concerned. Oh, that's what. You will do it. Not 1 week. In 2 days you do it. What you will do? University, nothing. No. Let us we will see. Otherwise, it will be delayed. The entire it become today is 7th. Shall do on or before 16th of the month. On or before, instead of 10 days, on or before 16th November. The entire exercise shall be completed and intimate the outcome of the same to the petition institution. Yes, sir. Full stop. Sorry. Now, she promote Lana Council appealing for the respondents. Argued that the intake was fixed based on the scorecard, which is that score. Page 1 niche. Score report evaluated based on argued that the university had taken decision based on the score report evaluated by the LIC committee. That's all. Yes, sir. Today it will be released. No delay. Yes, sir. Which is that one? Yes, whatever you think is you serve it better. But go to the merits of your application. Need not be just you pointed out what is the merit in the petition. Or else it may be taken up in one day B group. In 2:30 I will take it up and dispose. Amendment application. No, nothing else. So next Tuesday, sir. 15th at 2:30. Please, sir, whatever the copies, you are also. So, list on 15th. I think 16th at 2:30. With an understanding that maybe taken. 16th at 2:30. Yes, amendment. Maybe allowed. Sorry. Liberty maybe. Very well. Sorry. Accepting the cause shown in the governments made in year 1 of 2020. Amendment application filed by the petition is allowed. And a council appealing for the petition is permitted to file the amended petition. You see, in the meanwhile, the respondent authorities are liberty or reserved liberty to the respondent authority to file additional statement of objection if any. You can file it in registry. Chandrasekhar Party, no representation on behalf of the parties. List after 2 weeks.
I appear for respondent in this matter.
Mr. Chandrasekhar Patil is not there.
It is not there, but I appear for respondent number 2.
Yes.
223.
Two weeks. It's not keep, he underwent some cycles. List after 2 weeks. Let it be. List after 2 weeks at the request made by the Lana Council appealing for the petition. Interim order granted earlier extended till next of year. Accepting. Yes, Mr. Raghupathi.
My lord, LR application, my lord, one of the petitioners
Maybe
is
allowed.
deceased. My lord,
Considering
my lord, I
the-
request a date may be given, my lord, a simple matter now. Though there are
Yes.
8 prayers, my lord, most of them are complied with by the state government now. Only with regard to the mandamus, my lord, if the matter were to be taken up somewhere on 16th or 17th, my lord, I'll file the amended writ petition by end of the week.
Yes, accepting the reasons stated in the application in year 1 of 2020, the year 1 of 20 is allowed, petition is permitted to bring the legal representatives of the deceased petition number 18 on record and to file the amended petition. Yes, and to file the amended petition. Yes.
A date may be given.
No, let us will see.
Only the mandamus portion would remain. That's all, my lord. All other
13, list,
has
2 weeks for 28. List on zones. Yes.
much obliged.
R3. You are appearing for the R3 A and B also. Sorry. Accepting the cost shown in IA 121, then a council appearing for the petitions permitted to bring the legal representatives of the deceased R3 in bracket A and B full stop. It is submitted by C.K. Manohar Chari, then a council that is representing the legal representatives of the R3 within bracket A and B. Then a council appearing for the petitions permitted to amend the cost and to file the amended petition. You sir amended petition. They will. Yes. Yes, madam. It is submitted by next cabinet meeting. It will be taken. Normally they will used to say that. Even when I was there also, they will say 6 months. You submit like that. It's not correct. If you take up any issue, tomorrow they will take it up. I know. I will say that next cabinet meeting. Yes, any day. You hold it after 6 months. Next cabinet meeting. Better. Sorry. On the last occasion, this court has observed that the issue involving in this petition will be taken up in the cabinet meeting. However, no further action has been taken by the respondents state. That you have to matter. It is directed at the respondent. They say they will take it up. I'm aware of this. Otherwise, they won't take. Respondent number 1 is respondent number 1 and 2 is directed to put up the issue relating to the petition before the cabinet meeting, before the next cabinet meeting, taking into consideration the urgency involved in this matter. To take order and pass better. Otherwise, they won't take it up. RGS. Yes. Just a minute. 10th up? Yes. Previous. So on 15/6/22, this court has not to the respondent shall not announce the result of petition without permission of.
Shall not have any equity
Yes, sir. What is your submission on this point? On 15/6/2022, this court has passed this said order. Third, the Lana Council appearing for the petitioner as well as source. City Krishna Lana Council appearing for the petitioner contended that, comma, when will be the 10/11 will be the for Mrs. T. Krishna, comma, made available the revised notification dated 10/10/2022 and stated that the last day for making payment for ensuing examination will be on 10/11/2022 and therefore, argued that the respondent university be directed to announce the result of the students. The said submission was opposed by Mr. So-and-so on a council appeal for the respondent. However, taking into consideration the order dated 15/6/2022, whereby this court has permitted the petition number 2 to 13 in the examination of first year B Pharma, and therefore taking into account that the fee for supplementary examination will be paid by 10/11/2022. Therefore, I am of the view that the respondent university shall announce the result of the petition number 2 to 13 and 2 to 13 forthwith. However, the appearance and the result of the such students to be announced by the respondent university shall subject to the result of the request. That is all. That is always it is open. You may not take also. You may end the course also. Told him. And delivery. List out agreement. Yes. 1 minute. Yeah, cause list. Just one. Cause list. Yes, dispense with production and so on. So dispense with production. Yes, sir. Monday Medical Residence to admit the petition to the second year MBBS course. Yes. Why you are taking? Annexure H is challenge. ವಿತರಣೆಗೊಂಡ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ದ್ವಿತೀಯ ವರ್ಷದ ವ್ಯಾಸಂಗದ 30? Yes, sir. Yes, sir. But only thing that they have to consider. Next at G, page 29.
Page 29,
Just you consider the representation of the earliest. That may be your endorsement. No, that may be your endorsement. Where is that? Direction National Medical in the Vaidiki. Yes. Then you have to complete the 11/8/2022. But whatever may be the thing, these four aspects that you have to.
I appear for respondent number 3, my lord.
Yes.
I appear for respondent number 8, Lordship.
No, pursuant to your application. Now the government has taken a decision. Go to 38. Sarkari Vaidike Kannur Linda. So NOC from the your parent college. NMC 20? Yes. National Medical Commission. So according to National Medical Commission is the competent authority. Just one. Yes. Where are you? Yes. Your application dated is on the subject. It's informed that your request for. Yes, sir. Has been examined so and so, and your request for migration and medical has been that you have already considered. Just a minute. Anyway, the NMC has given approval. Paraphora. For a purpose of migration, an application candidate shall obtain NOC. The college, that is a parent college that years. Yes. Anyway, whatever the in the endorsement 11/8/2022, it's already been considered by the NMC. Sorry. 1 minute. Yes, sir. Yes, sir. Just implement the order date of 1st August 2020. Anyway, they have already, I think, by the time. Yes. Within how many days that you would take decision of 1st August 22? Take instruction tomorrow. Very good. No,
May I
no.
make a submission, my
Yes,
lord?
sir. Yes, sir.
I have no objection, my lord, if the petitioners were to be accommodated in Mandya
Accommodated,
Medical
very
College.
well. Very well.
Mandya, my lord, I have no objection, absolute no objection. But in Mysore, my lord, the candidates have been filled up, my lord, we have no vacancy.
Madam will take instructions. Day after tomorrow. Nadida.
Acha.
Yes, impleading. Vinay. Election is over. Now, correct. That has been done. Anyway, letter will be heard in the matter. Nothing will happen. Allowing his application.
They have given an affidavit to us saying that we have not given any. That's a kind of.
Do one thing. Let us, we will allow these impleading applicants. How many? Just 1 minute. How many are there, sir, in the impleading? There are 5. 3, sir. 3. So according to you, 2 of them have in your favor. Filing application. Then impleading application. Ravi Prakash and Manjappa. What is their serial number? Manjappa is yes 21. How can it be? Petitioner, both petitioner as well as the respondent. And the only thing is writ petition allowed and dismissed. Writ petition is allowed and dismissed. Both petition and respondent is one and the same. No? That's why I said writ petition be allowed and dismissed. Petitioner and respondents are same parties. Do one thing, let they will file an affidavit. Better. Let they will file an affidavit. Either be in the left side or the right side. How can it be told? Impleading heard on IA 1 of 2022. And a counsel appearing for the petitioner contended that the impleading applicants dash HS Ravi Prakash and P Manjappa are the petitioners in the writ petition and therefore oppose the impleading application. In that way of the matter, the impleading applicants, Shri HS Ravi Prakash and P Manjappa are directed to file an affidavit stating about their stand in the writ petition. Let us will take it. Now we will file. You will file affidavit or file affidavit. Then who will file? Both of you can file common affidavit. That's all. Await service of notice for respondent number 4. Let us visit.
Also file. That also will not file is right.
Let us see their stand. It has to be connected with the WP number. Yes.
One more petition of 22.
21 of 22. Next week date, Kudla? Next week on date. 560. Let the application be, let the disposal of the petition. Instead of order of better. J and J.
Okay.
Aye.
Now it is simplified. Take the resolution.
One minute. J and J one alla. Page J. No. Before which authority? R5 alla. R5. In this petition, comma, notice agilala. Leonard Madam so and so. Correct. Except notice for respondent number 1 to 5. 1 to 5, comma. CP Anand, Nana counsel appeared for the aviators, as well as the respondent number 8 and 10. In this writ petition, comma, the petitioner has challenged the order dated 17/9/2021 in dispute number JRB/MD/26/2021-22 and in bracket annexure J and order dated 17/9/2021 in dispute number JRB/MD/27/21-22 in bracket annexure J1 passed by the respondent number 5 hearing. Heard the Nana counsel appearing for the parties. The petitions hearing have challenged the impugned orders passed by the respondent number 5 in an interlocutory application and taking into consideration the factual aspects on record, comma, I'm of the view that the respondent number 5 factual aspects of the case as well as the arguments advanced by the Nana counsel appearing for the parties, comma, I'm of the view that the respondent number 5 shall complete the entire proceedings produced at annexure J and J1 respectively within 3 months. 3 months first hour. 6 months of there. Within 4 months from the receipt of this order. Within 4 months from what about them? Within 4 months from the receipt of this order. It's also made clear that this court has not expressed any opinion on the merits of the case, and the respondent number 5 shall independently consider the issue involved in the matter in the dispute and pass appropriate orders in accordance with law. Yes. Yes. Just a minute. Sir, copy. Yes, sir. Rajiv Gandhi. Yes, either. Check whether it could be disposed of. Correct. Or else, can you take instructions by tomorrow? Huh? Tomorrow. Huh? Nadittu. Sorry. Madam so-and-so accept notice for respondent number 1. She so-and-so accept notice for respondent university. Day after tomorrow. Monday will. Here, at least by 10th. 10th. This on 10th. Yes, sir, copy today. Sir. Yes, sir. So, on IA number 3 that you. Yes. Where is that order on IA 3? You doesn't want to deposit the amount. Where is that award? Annex D, Allah? Correct. 5,81,480. ಮೇಲೆ ಮುಂದಿನ ಬಡ್ಡಿ ದರ 16% ಹಾಗೂ 3% ದಂಡದ ಸಂಪೂರ್ಣ ಪಂಚಾಯತ್. Yes. 40? Yes. $43, sir. Please read. The 7,60,000.
What was the purchasing it? And there is
no, 7,69,000 was claimed. Correct. So what is claim? 7,69,285 by the society. One minute. He says that 7,69,000. Adesha. Yes, sir. Which is correct actually.
Because they are not as per the have paid home. By 19,40,000, it has not been distributed by the first respondent society.
Yes.
It is accepted. Based on that, the previous month,
What is the order passed by the appellate tribunal? Filed under regulation 37. Since 105 of the Act is mandatory, the application do not survive as such application is. Yes, sir.
My prayer is not to separate.
Then you have to pay the highest one is 7,69,000.
Still, I have paid more than that.
You might have paid to the society. No, you might have paid to the society, but you challenge the entire order, entire award. But what is the claim made in the appeal? At least 7,60,000. For that you have to pay.
No, I need not pay it. Why? Because I've paid more than that.
You pay and you pay better. It is a statutory.
Passing the one directly.
Sir, it is mandatory. Yes, sir. 34.
Level comes from respondent number one, price before it went on the each before. Or single distance. When it comes to respondent number one, both sides.
Single number was given. How come, madam? How come 2 hours? How come 2 hours for a single case? There are 2 hours are passed under single dispute. Which order that you are challenging? Both the orders. Then you pay the highest one. Which is the highest one? 7,69,000. There are 2 hours. 41. ಬಾಕಿ ಉಳಿದ ಅಸಲು 1,60,000 ಮೇಲೆ ಮುಂದಿನ ಬಡ ಬಡ್ಡಿ ಸೋಮ.
So this is the
It instructions. There are 2 awards for one case. Annexure. Of course, it is stated by the government itself. There are 2 awards for one case. Either one award will be the correct. You get instructions. Issue emergent notice to 1 and 3. Madam so and so learned AGA accept notice for respondent number 2. Stay of order dated 10/8, no, 10/8/2022 till next set of year. You take first one, or else you file a memo. The council appearing for the petition has filed a memo stating that notice to respondent 3 be dispensed with. Accepting the memo at the risk of the petitioner, notice to R3 is dispensed. File a memo. Yes, sir. Yes. So annexure R is challenged. Yes, sir, correct. That the university shall take. I will issue notice.
Already studied there, they are not prevented from seeking further education.
Let you, sir, copy to the university letter. We will hear that better. 60? Yes.
Government do not have committed. All
64, sir. 25/11.
government has all used, but these students who have studied the certificate, those students will drop out.
You, sir, copy. I will take it up on Monday. Let us. By the government. Annexure K. ಮುಕ್ತ ಶಾಲೆ ನಡೆಸಲು ನೀಡಿರುವ Yes, ರದ್ದುಪಡಿಸಬೇಕು. Yes. Production elected.
This was again challenge.
Anything is further proceedings has to be stayed there, sir. Let us listen. Tony. Madam, so and so accept notice for respondent number 1 and 2. She B Pramodalla appear accept notice for respondent number 3. In the meanwhile, stay of the annexure, stay of the notification dated 15/9/2022 within bracket annexure R to the requisition. Just one. Anyway, if the annexure are stayed, then they have to permit them. Huh? But we don't know the eligibility criteria. Many things. Anyway, I stayed annexure R. Let us. Otherwise, it's very. That they will do. Today itself they will do. No, ಇವತ್ತೇ ಮಾಡ್ತಾರೆ. Already annexure H. That is 25/11/2021. Correct.
there is a law that it's to be admitted. Otherwise,
Who has to admit at the university? Only to attend the classes. Yes, ma'am. But she has to say that she has to say Annexure H I have seen 2511 eligibility criteria. Sir, copy letters, please. That's but Leonard AGA is directed to communicate the order passed by interim order passed by this court today, and to direct the respondent university to allow the students to direct the universities to allow the students to attend the classes subject to their eligibility in terms of 25/11/21. Admit the students in terms of the letter dated 25/11/2021, taking into consideration the eligibility criteria. Yes, madam. Just search. That I have already. Will be released. Told. But misappropriation is stated. Let will file objection. Let us take it next week. Monday we will take it up. Monday or Tuesday. So notice Leonard AG accept notice for respond number 1 and 2. Here for this 3 Allah. So respond number 3 is represented by way of KV8 petition. This matter stop. Yeah, the mailgade. Lana Council Sri NR Krishnappa appearing for the respondent society seeks short accommodation to file objection by Monday, so and so date. By Monday, full stop. This matter on Monday in preliminary hearing. Very well. List on 16. List on 16th. By Monday you file. Very well. List on 16. In preliminary hearing. Yes. 24, 27. Leonard AG accept notice for respond number 1 and 3. CTL Kiran Kumar accept notice for respond number 2. Issue emergent notice to respond number 4 and 5. Respondent society shall permit the petitioner to cast their vote in the ensuing election to be held on 11/11/2022, and the interim order is subject to the result of the election. Let us get it. 27. Then delivery. Yes, yes. For our Fatima. Why? Huh? Yeah, BSH in your illegal. MS. It is so and so accept notice for respondent number, respondent university. When do you want? It's our copy yesterday. Day after tomorrow. We will, huh? 10th hour. 10th. 10th in preliminary. Yes. 10th in preliminary. What is to be considered? Just a minute. Who are you, sir? Who are you? Yes. Against? Against? Against present. Yes. Where is that Annex E? Yes. Yes, ma'am. Consider. Third. Madam so and so third. Madam so and so accept notice for respond number 1 and 2. Full stop. Notice 2, 3 and 4 is not is dispense with. Full stop. Having heard the Learned Council appearing for the petitioner and the Learned EGA representing the respond number 1 and 2, and taking into consideration the contents in the representation dated 6/6/2022, in bracket annexure E to the petition, the respond number 2 is directed to consider the representation dated 6/6/2022 within 8 weeks from the receipt of this order. 8 weeks. They have to do a lot of things. Nothing is within 8 weeks from the receipt of this order and communicate the outcome of the same to the petitioner. Full stop. It's also made clear that this court has not expressed any opinion on the merits. Next. Petitioner, Madam, accept notice for respondent number 1, 2, and 3. 1, 3, and 4. Then the AG accept notice. CTL Kiran Kumar for 2. Issue emergent notice to 5. Full stop. Petition. I said the respondent authorities and the society are directed to permit the petitioner to participate, contest and cast their vote in the election scheduled to be held on 20/11/2022. Yes. It's also made clear that the interim order is subject to the result of the election. Yes. that this provision has been held valid. That's it. If see what your challenge is, rule 85D and 88. No, just one. This is what your challenge is. Whether this provision has been held valid. Oh. It's not a borrower. What is your locus standi then? What is your locus standi then? You are no way connected with the bank. You are no way connected with the bank. You have purchased from the borrower. Then how you are, can you maintain the petition? That's. Any action that has been taken by the bank against you is subject to the DRT. Anyway, I know the Securitization Act itself has been held valid. I'm aware. It is reported in SEC also. Very good. If you want to challenge it before the DRT, let you. No, not like that. You anyway, you are not a borrower. You are not a borrower. No, you file this petition in the garb of challenging the validity. Procedure that petition will be maintainable. That's. Tomorrow. Let will go through. Yes, sir. Or else better liberty will be reserved for you. Challenge. Get it tomorrow. At the request made by the Lana Council appearing for the petition, this tomorrow. Except the judge, except the judge, parties know the case. Normally, except the judge, parties know their case. That's well such a tomorrow. Or else I can dispose of it direct if a liberty will be reserved today. Yes, let us visit. After 2 weeks. After 2 weeks. No, sorry. No representation on behalf of the petitioner. Just after 2 weeks. Comment. 32. Passport. Pretty good. 20. 21. In the order sheet.
From what they drawn, and it subsequently declaration and the real allegation to this report. On the report, they think that we are not getting the right.
Just withdrawn, and thereafter yes, ma'am. February 21st. Writ appeal against the order dated 21st February against the order of withdrawal. Now they came. We'll say we'll dismiss the petition. I think. Anyway, you are not arguing. Yes. No representation. I will dismiss it. No representation. Let us no represent. Stop. This petition was disposed of, was dismissed as withdrawn on 21st February 2019 by this court, and thereafter, it was brought to the notice of the court by Leonard ESG that the said order was challenged in writ appeal number 3073 of 2019, and the division bench of this court by order dated 5th September 2019, reserved liberty to the petitioner to approach this court by way of appropriate application, and thereafter this court by order dated 8/11/2019, set aside the order dated 21st February 2019 and restored the writ petition on file. However, no representation on behalf of the petitioner. Petition is dismissed. Dismissed for non-prosecution. Dismissed for non-prosecution. So they are aware about the result. Yes. Janardhan. What is this petition? Let us listen. Memo ಇದೆ ಯಾವತ್ತು ಫೈಲ್ ಮಾಡಿದ್ರಿ ಮೆಮೊ IFR just As per use, intake is annexure J. As per annexure J, just a minute. Where is annexure J? Just annexure J. $58. Correct, sir. Where is that? Intake approval for 1920. 45. $45 ಅಂತ ಇದೆ.
60 earlier it was 60. Yeah. Yeah, Richard.
49. Page, sir. Page 23. 23. This is in respect of your college. Intake approval for the 15-16 is
Continuously it was there for 80. This all the years.
so intake was 60. Now they have reduced to 45. Why they have reduced? Yes. Yes. 54. 54, sir.
Last
54. Just one.
Serial number 49.
Participation in national innovation ranking. So up to 60. So they have 19 because this is for 19 and 20.
Subsequent years,
Yes. Yes, sir. What is challenge now actually? Annexure? Just 1 minute. One minute, sir. One. Annexure, what was restricted up to 45, sir? You have to make it only 60. Now they have complied with. Anyway, now they have restricted up to 45. Now you can visit there, conduct an inquiry. In accordance with in the event if everything is complied with, make it 60. Yes. Sorry. 50? Anyway, you are going to visit. inquire. If any deficiency is there, you can ask them to rectify this.
This example is request to give minutes.
Yes, third is. Please sit down. In this writ petition, petitioner institution has challenged the order dated 17/5/2019. You can bracket annexure K and annexure J you are not challenged. And the order dated 29/4/2019. You can bracket annexure J to the writ petition. The relevant facts for adjudication of this petition are that, the petition institution, has established the engineering college, imparting civil imparting imparting education to the engineering course of various disciplines. Full stop. As per in civil engineering, diploma or not be diploma engineer, diploma engineering, but engineering in diploma engineering. As per annexure C and D to the writ petition, the permission was accorded by the respondent authorities to admit 60 students, in the place of 45 and 40 against each subject, and accordingly, same was extended by the first respondent for the academic year 2015-16 up to 2018 and 19, full stop. However, as per the guidelines of the first respondent university, first respondent, the approval was accorded for intake of the 45 students pursuant to the deficiency report produced at annexure G to the writ petition. Petition hearing has challenged the impugned order, restricting the admission for 45 students based on the deficiency mentioned in the report produced at annexure G to the writ petition. Hence, it is also stated in the writ petition that the petition herein has complied with the deficiency as reflected in the annexure G to the writ petition, and therefore, presented this writ petition seeking intake of 60 students to the diploma engineering course. I heard Shri Janardana Ji, Lana counsel appearing for the petitioner, and Mr. Shauri for the respondent university. Shri Janardhan, Lana counsel appearing for the petitioner, contended that earlier the admission was given for 60 students. However, same was restricted to 45 students. Taking into consideration the report produced at annexure G to the writ petition, he further contended that, the complaints highlighted in the annexure G to the writ petition has been complied with, and therefore, he submitted that there is no impediment for the respondent number 1 to which respondent, sir? Respondent 1 to accord permission for intake of 60 students as against the 45 students as stated at Annexure J to the requisition. And a counsel appearing for the respondent opposed the writ petition and stated that, in terms of the report made by the in terms of the report produced at Annexure G to the writ petition, permission was granted for admission of 45 students, and therefore he contended that there is no merit in the petition. Having heard the learned counsel appearing for the parties, it is not in dispute, that the earlier the respondent one has accorded permission for intake of students. However, taking into consideration the report produced at Annexure G has restricted the admission to the admission to 45 students only. Full stop. He said permission as per Annexure J was intake approval for the academic year 2019-20. Full stop. There, full stop. However, this court, directed the petition hearing to file a memo stating about the strength for the academic year 20-21 and 21-22, and in furtherance of the same, the petitioner institution has given an undertaking by way of memo stating that only 45 students in the aided subjects for the academic year 20-21 and 21 and 22 has been admitted insofar as the civil engineering, mechanical engineering, and electronics and communication engineering, and same is in accordance with Annexure J to the writ petition. However, taking into consideration that the petition institution is imparting education to the total masses in the said locality, and the respondent number one had accorded permission for intake of 60 students at the earlier point of time. However, same was restricted to 45, taking into consideration the Annexure G to the writ petition. In that view of the matter, I am of the view that the respondent number one shall visit the petition institution, and taking into consideration the eligibility criteria for meeting for 60 students afresh, and thereafter considering the report that may be filed by the expert committee of the respondent number one, and thereafter take decision in the matter to approval for intake of 60 students for the which is next academic year, for the academic year 22-23 at the earliest, and say full stop, at the earliest, full stop. The said exercise shall be completed by the respondent number one within 1 month. They can do within 8 weeks will be too long by the time. Within 6 weeks from the receipt of this order, and in the event if the respondent number one is satisfied with the compliance of the requisite compliance with the requirement as per their needs, same shall be considered and approve the same at the earliest. Thereafter, within 2 weeks from the receipt of the report by the expert committee. However, it is to be clarified that insofar as the academic year 19-20, the respondent authority shall approve for 60 students as by virtue of the interim order passed by this court. The petition institution has permitted the 60 students for the academic year 19-20. 1920, and there whatever the results, and it's also stated by the Learner Council appearing for the parties that they admit that the respondent has announced result of the 60 students for the academic year 2019 and 20, and in that way of the matter, same should be approved forthwith. Yes, by the respondent. Accordingly, the writ petition is disposed of. Thirty-six. Crossover is not possible. Any other date may be taken. Your friend is next time. See to that. Maybe two, sir. 2:30. Some other matters are there. That's right. Or else, only thing is, all of you have to wait till 4:45. Then you have to say it's not possible. When at the request made by the Learner Council appearing for the respondent number 5 or 6, 6 list day after tomorrow. See to that it will be taken up. Yes. The request made by the Learner Council appearing for the 2 weeks. List after 2 weeks. Interim order granted earlier, extended till next step. Submitted by the Learner Council appearing for the petitioner that the prayer made in the writ petition has become infructuous. Accordingly, writ petition is disposed of as becoming. Yes. Yes, sir. Harish Shamji. Harish Shamji, appear at the moment. Then
somebody else has come in. The meantime,
nothing survived.
based on the
No. YD. See, YD Arsha. Yes, YD Arsha accept notice for respondent university as it is submitted that Sri Harish MG is not appearing for the respondent university. Yes, sir, copy to YD Arsha, another council. By the time you also get that, if in the event if it is approved, then as it become infructuous. Yavat Corona date. 10th or 14th? 14th. 14th. In the event if by 14th you will just came to know that if it is infructuous, just you can mention in the morning itself. By the time you sir copy to Mr. YD Arsha, he will also get instruction from the university. Yes. Sayed Abra, but if yes.
What is it? 42?
Yes, sir. But
I am for respondent.
yes, sir. Yes. Sir. No, when the opportunity letters will be. Sorry, no representation on behalf of the petitioner, in order to provide an opportunity to the petitioner. This one date could be.
Lord, is it 42, my lord?
Yes, sir. Yes.
Yes, I am for all two. We are college ಮೇಲೆ ಗಲಾಟೆ ಮಾಡ್ಕೊಂಡಿದ್ರು ಹುಡುಗರೆಲ್ಲ.
15th. Let us take.
15-11.
Yes. Yes, sir.
15-11.
Yes, sir. 15-11.
God bless.
Some unmute your systems.
Please.
Mohan. Sir, unmute mode.
Sir, unmute your system, sir. Mohan, yeah.
Sir, mute agide.
Yes, no,
Ah.
can you hear Lordship now?
Now I am hearing. Yes, sir.
Yes, Your Lordship. Before the petitioner, Your Lordship may kindly see this matter pertain to the infrastructures to be provided by to the schools as per the government order dated 2011-2020, Your Lordship, in
Yes,
which the petitioner association have challenged the Your Lordship may kindly see Annexure A is the order passed by this Honorable Court when we questioned earlier.
What they are seeking, madam, writ of
Yes,
mandamus
earlier petition.
respondent to strictly follow the judgment of the apex court. That we have
Yes,
to
Your
follow.
Lordship.
That we have to follow.
They are not, then representation was given, Your Lordship.
And passed the letter dated first respondent by third respondent produced at annexure G to the writ.
Yes, Your Lordship. Because after filing contempt, they issued this to endorsement. And by virtue of that, they constitute a committee now.
Manya Sarvocha न्यायालय so on so. Yes, sir.
Now, the simple, only one question is involved. Honorable Supreme Court has said, for all
Yes.
existing schools, I have to follow only the, kindly see the paragraph, relevant paragraph, Your Lordship, of the Honorable Supreme Court, which has been called out in the Annexure A itself, Your Lordship.
Annexure A.
A itself. Which is first month in the
Where is that,
request
sir?
all existing government and private schools shall install fire extinguishing equipment within a period of 6 months.
Where
And-
are you reading, sir? Where are you reading?
Annexure A, Your Lordship, in the writ petition.
Annexure A, yes, sir.
And no, I have produced the Supreme Court judgment also separately.
What do you mean? Just 1 minute, sir. 2009.
Number 483 of 2004, Your Lordship.
398.
Judgment is submitted next.
One minute.
Yes, please.
Please read, sir.
ಯಾವ ಡೇಟ್ ಅಲ್ಲಿ ಸರ್ ಫೈಲ್ ಮಾಡಿರೋದು?
Along with the memo, Your Lordship, along with the memo subsequently. And memo was written with some office objection, it seems.
Government statement. Along with the memo, na?
Yes, sir. In fact, that has been referred in the notification, Lordship.
The date of the memo, sir?
I don't remember, Your Lordship. Because right now I am in Chennai, I am doing video conference through.
Yes, sir, very well.
That is referred in the order, Your Lordship, which has been passed, Annexure G, Your Lordship.
Annexure G.
G and
Let
L.
us
They are referred to that order.
go to Annexure G for a minute.
Yes, sir.
That is order dated
Contempt, they
15/7.
produce this endorsement.
15/7/2021.
Yes, Your Lordship.
Yes, sir.
They refer to the paragraph 1 that in that paragraph 1, Your Lordship.
Yes, sir. Yes, sir.
Then
Please read.
subsequently, Annexure G, H is also included. Endorsement, another H, Your Lordship.
What is stated by the Honorable Supreme Court, sir?
Honorable Supreme Court has specifically said all existing government and Kannadadalli ಹೇಳಿದ್ದಾರೆ ಆಮೇಲೆ ಇದರಲ್ಲೂ ಹೇಳಿದ್ದಾರೆ ಇಂಗ್ಲಿಷಲ್ಲೂ ಹೇಳಿದ್ದಾರೆ endorsement which is issued
Where is that? Where is that actually?
Annexure G, Your Lordship.
Annexure G. Yeah, Annexure G I have. Where is that, sir?
That is dated
15/7/21.
2021.
Correct. Where it is stated by the Honorable Supreme Court.
That is followed by another endorsement, Your Lordship.
Where is the Supreme Court says?
Otherly, then another endorsement issued Annexure H also.
2000.
Document.
2009, 6 SCC 398.
Oh.
Take the book. Yes. Now what has happened, sir? Now whether this government has.
No, subsequent to that, as per Annexure H, they constitute a committee because for all existing schools, how to go about it? That is an issue.
Annexure H.
H, Your Lordship.
Yes, sir. All existing government and private schools shall install fire extinguisher. That has to be done.
Yes.
Yes.
That has not till date, no decision has been taken on that as far as the committee is concerned. Committee has to examine now. Before that itself, now they are all inciting us to obtain fire clearance because now you are aware if the Honorable Supreme Court has simply said I should have fire extinguisher equipment and teachers should be trained with handling how to solve the fire.
How to, yes, correct.
Government schools and private schools.
Yes.
So now by they are harassing the schools and see that you all obtained the NOC from the fire as well as other authorities so that we are only concerned about the existing school. From 2018 onwards, this what they issued a notification. Let it apply to the new schools. We are not coming in the way. As far as the old schools are concerned, they as per the Honorable Supreme Court judgment, we are following it and we are doing it. And even then also, the committee has to look into this aspect and come to a conclusion. So the committee has not given the report till date. That is also one of the prayer in my petition.
Where is the constitution of the committee?
To the same extent.
Where is the constitution of the committee?
Pardon?
Where is the constitution of the committee, sir?
Annexure, they have to constitute that are relate till date. Annexure refer to a constitution of the committee.
Granting recognition or affiliation, the concerned state government and buildings are safe and secured from every angle and they are constructed according to safety norms incorporated in so and so. Where is the committee, sir?
They are not constituted, Your Lordship. That's what.
Where is the constitution of the committee, sir?
They have to
They
do
are
it.
not constituted. Where is it is stated that a committee has to be constituted?
May I read that? Government order, they report 10th March 2021, Your Lordship. They report in that.
10th November.
Annexure E is the update filed in the contempt. That copy I enclose, Your Lordship.
Annexure?
Annexure E, Your Lordship. Order of the complaints update by the education. Yes, Your Lordship.
Where it is stated?
In that annex that government order.
Where is that, sir?
In the affidavit, they say they constitute a committee. In the affidavit filed in the contempt.
Sir, where it is stated?
10th March 2021. They have produced a government order.
10th March?
In that, in the contempt proceedings, affidavit is filed by the government, wherein they refer to the
in the affidavit where it is stated order, that they have constituted a committee, sir.
Yes, Your Lordship.
In the affidavit where they have stated that they have constituted a committee.
Committee to review and ensure the complaint. That's what the language they use. Review and.
Where is that? Where is that?
In that very affidavit, Your Lordship.
In the very affidavit, which line on the affidavit?
Like.
Which line in the affidavit it is stated that
I just
paragraph 4.
Yes, Lordship.
Paragraph 4 ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ as per committee. Yes, now. Yes, now what is the grievance of the petitioner?
My grievance, Your Lordship, by virtue of this notification.
Just,
And
yes, sir.
they had not followed the Honorable Supreme Court order, what I contemplates for existing schools. It also applied to government and private and aided schools also, where it says only I should have the minimum equipment of fire extinguisher equipment and the conform to the building code.
No. What is the grievance of the petition in this matter?
Sir, grievance is that
One is comply with your Honorable Supreme Court order.
yes, that's all.
That's
Because
all.
earlier also Annex A
Then
kindly
they have to comply with the Honorable Supreme Court order.
They are
Anyway.
also very specific. What they are saying, I should have 10,000 liters of tank and 12 meters of road width turning and ground suspense space for the fire engine to enter. That is the Annex A. Kindly see the observation of this Honorable Court. That is
Just
impossible. That's what the Honorable Court-
what you are challenging this petition actually?
Last paragraph, before one paragraph.
Just- What you are challenging this petition, sir?
Grievance, what referred by the
Letter dated third respondent, so and so, Annex G and H. Annex G and H has to be quashed. Why it has to be quashed now?
No, my response submission is that they issued earlier notification in 2020 November, which is questioned in the earlier writ petition as per Annex A order, Your Lordship. In that, this Honorable Court has specifically observed that keeping in mind with the existing schools, last but one paragraph, Your Lordship. Annex A.
Yes.
10,000 liter tank capacity, Your Lordship got it. Annex A.
Yes. Annex.
Annex A.
The other
And
condition
road-
is that institution should have an overhead tank with a high capacity from storage of capacity 10,000 liters. The petitioners have made representation to this. Stand this direction to respond. Consider the representation.
Yes, Your Lordship.
They consider representation bearing in mind the Honorable Supreme Court order. So
They are
this is
not
the
done,
order.
that's what-
Yes, sir.
Because my representation is not considered as per 1st March 2021 order, then I have to file contempt. Now in the contempt, they rely on these two Annex G and H endorsement now, which is contrary to
G and H.
contrary to the Honorable Supreme Court order.
How do you say that it's contrary to?
Kindly see the Supreme Court order, Your Lordship, paragraph.
Yes, which yes. Now I have this.
Paragraph 47. Paragraph 47, Your Lordship.
No, which Supreme Court guideline has to be looked into, sir?
That it says that paragraph 47, Your Lordship.
Paragraph 47 of the Honorable Supreme Court order.
Yes, Your Lordship. That is
In view of what happened in so and so. Yes, sir.
paragraph 47.
Yes, sir.
All
Before grant,
existing- Your Lordship, but
the state government and union are directed to ensure that the building is safe. Yes, so sir,
direction given.
five guidelines have been laid down by
Yes,
the
sir.
Honorable Supreme.
Then subsequent to that, paragraph 47, Your Lordship.
That is 47.
47.
Read 47, please.
Yes, Your Lordship. At paragraph 47, Your Lordship.
Yes, Odi.
All existing government and private schools, the language
Yes,
shall install fire extinguishing equipment within a period of 6 months, and that the school buildings be kept free from inflammable toxic material, and if storage is inevitable, they should be stored safely. It also further added
Yes.
about the evaluation of the structural aspect.
now within 6 months that they have to take a decision.
Yes, sir.
Ah,
So
this is
our grievance is that existing schools, we can't have 10,000 liter tank capacity, and also the road width cannot be have that we can't modify it now for the radius to turn the. So these are the representatives which we are given. Without considering that respondent, they again issued annexure G and H, which is contrary to this paragraph 47 of the Honorable Supreme Court. So our only request is that existing schools, they can't insist. For after 2018-19, we have issued these guidelines. Definitely that can
But
be.
the Honorable Supreme Court said that for all existing government and private schools.
It's only a minimum requirement, Your Lordship.
Where is that?
Shall install fire extinguish equipment. It doesn't say NOC from fire force.
Shall install.
That's all. But they are now insisting NOC from firefighting equipment.
Oh, it is not there. According to you, that obtaining NOC from the fire brigade is not necessary.
Yes, not necessary. And also the as far as the minimum building requirement is concerned, the structural engineers every year they have to evaluate it. Again, I need to go and do it. That also it will be hard. Now the another problem is why we have moved this court. We also mentioned interim order. They are not reviewing the RR.
Sir, now pursuant to the order passed by the Honorable Supreme Court,
Yes.
the impugned annexures have been, impugned circulars have been issued by the
Yes.
government. Just to say how the impugned notification are contrary to the Supreme Court.
Because now, by virtue of this notification, they want to have a constituted committee now. Let the committee decide.
Whether committee is constituted, madam? I think in contempt, in the contempt petition, you filed an affidavit of the secretary. So pursuant to this, one more the notification is 18/5/22 is passed. Pursuant to the filing of this petition,
Yes,
one more notification dated 18/5/22 is issued.
that is not because this
That is not the subject matter.
yeah, no, this
That was
earlier.
where is the
This petition on 7th March 22
the Salas Patra Padiyu ಬಗ್ಗೆ? No, where is that in the Honorable Supreme Court order? We say that, just to use read the judgment, all existing government and private schools shall install fire extinguisher equipments within a period of 6 months. What
all
step?
the schools are done.
Yes,
All
sir.
schools are doing it. Let them also class check it up. There's no problem.
Yes. How can you ask them to get the NOC every year and all those things? It's mandatory. Correct. Yes.
That 10/11/2020 one order was passed. That has been questioned in the earlier writ petition, where
Yes.
all these things have been stipulated contrary to the Supreme Court.
Hmm. 18/5/22. Yes. Six five. What you have stated here? Very well. So what his argument is that I think the 15/7/21 check G. Correct. Yes. So now what has happened?
Yes, Your Lordship.
When you are appearing in person, actually better.
Yes, Your Lordship. Kindly have it on 10th, Your Lordship.
10th hour, no?
10th August. I'll
Let
be
us
there.
see.
I'll attend.
10th,
Please.
10th, instead of 10th, 14th, 14th, 2:30. 14th at 2:30, let us say.
Please, Your Lordship. Definitely.
Because you have to say,
I know. I know
the
that.
order of the Supreme Court is there.
Please.
How
Please.
it is.
Yes, Your Lordship. I'm
Or
glad
else
to-
just you look into the new circular issued by them government on 18/22 also.
That is subsequent to the writ petition.
14th at 2:30.
Please, sir.
For further reading. For further reading. Yes.
Commissioners or students, which is a college,
Yes.
petitioners expulsion orders,
Oh,
which is annexure A to annexure H.
just 1 minute. What your challenge is the setting aside the impugned expulsion notices. NOC annexure A to Q.
A to annexure H. Which of those notices
Just A to E. Just a minute. You have 3-year studies tenure for the undergraduate. Yes, sir. According to them that you are involved in illegal.
the academic year 2018-19.
Academic 2019.
18-19.
Yes.
Petitioners 1 and 4 enrolled for the BCA, Bachelor of Computer Applications course. The other petitioners.
Yes, sir.
So the coursework was completed in the year 2021. The incident in question is after the coursework and college attendance was over. And their perusal of the order itself clearly shows this violation of section 7, subsection 2 of the Karnataka State Universities Act.
But universities, Karnataka State University. Statement is filed, Allah? Statement file madidra?
Statement Madida.
Who is appearing for file? Or which respondent, sir? College? That we will hear him also. That we will hear him also. When do you want? Any date of your choice. Sorry. Please also you file by the times. University, let. ಅದನ್ನೇ ಬರೆಯಿರಿ. ನಮ್ದು ಏನು ಇಲ್ಲ ಅಂತಾನೆ ಬರೀರಿ. Because earlier, of course, the answering party will be the college. But anyway, whatever the result will be announced based on that university, yeah, that you have to take. So, no representation on behalf of the answering respondent college. Number 3, full stop. In order to provide an opportunity to the respondent number 3, list in the 2 weeks. 21st, we will take it up. 21st. So that full stop. In the event if the respondent fails to file a statement of objection, same be filed by 21st. Let us please.
ಈ ಪುಟ್ಟೆ ತೋಡಕ್ಕೆ
What is this, madam? Election. List of ineligible voters noted. Profile, madam. Who is the answering party actually? Society. Ah. Granted. So now they are saying, yes, madam. Anyway, the elections are over. Results are announced. That's no, no. The results are announced. Then tribunal go back. 70. Dispute election tribunal. So no representation on behalf of the petitioner. And a council appearing for the respondents are present. List after 2 weeks later. In the meanwhile, you get it. What happened to the elections? Declared or not? Yes. 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 Where for the? So EP number annex H is challenge. Who are you actually? Oh, borrower. How much that you are supposed to pay? $4,45,000 ಅಂತ ಇದೆ. ಮತ್ತು ಬಡ್ಡಿ ಪ್ಲಸ್ ಬಡ್ಡಿ. ಈಗ ಡಿಪಾಸಿಟೆಡ್. You application seeking ಅಷ್ಟೇ ಏನಿಲ್ಲ. But the writ petition, what your challenge is annexure H. Now they have not done the auction. ಅವ್ರು ಮಾಡೋದು ಇಲ್ಲ. So ಸಿಕ್ತವ್ರ ಹತ್ರನೇ ತಗೊಳ್ಳೋಣ ಅಂತ. Maybe true. Only thing is anyway it's a notice, auction notice. No, it was not materialized, of course. Now it is open to make an application to them seeking this. Even otherwise take for an example. Even if this interim order continue, they may issue one more auction notice. ಬರ್ತಾನೆ ಇರಬೇಕು. You have to go. So, then once you put an end means you have to deposit the entire thing. Still normally. No, you very good. ಏನು ಅಷ್ಟೇ ಸಾಕು ಮಾಡ್ಬೋದು. Maximum 6 months I can say. I don't know, subject to what. Six months ಮಾಡ್ಸಲ್ಲ. ಇಲ್ಲ 6 months. 1 year ಕೇಳ್ತಾ ಇದ್ದಾರೆ, at least 6 months ಕಡಿಮೆ. No, I will leave it. Then can I say that 8 months 4 installment? Let us sorry. In this no 8 months ಮಾಡ್ಬಿಟ್ಟು 4 months. ನಿಮಗೂ ದುಡ್ಡು ಬೇಕು, ಅವರು ಕಟ್ಟಬೇಕು. Otherwise is in this writ petition. The petition is that is original agreement. See, that cannot be. In this petition, the petition has challenged the sale notice in EP number 4 of 22-23 in dispute number 6 of 21-22 by the third respondent dated 22/8/22 within bracket annexure H to the writ petition. Third, the Lana Council appoint for the parties. Petitioner hearing is a member of the which society, sir? Yeah. 5 branch managers of the 5th respondent society and has availed the term loan from the respondent society to an extent of 4,50,000. However, the petition became default, and as such, the fourth respondent has raised a dispute under Section 70 of the Karnataka Cooperative Societies Act 1959 before the Joint Registrar of Cooperative Societies Bangalore region, and in the said proceedings, the and in the and pursuant to the said that is over, and pursuant to the completion of the said proceedings, respondent society has filed EP number 4 of 22-23, and issued the sale notice in respect of the property in question belonging to the petitioner for having defaulted in payment of the principal with accrued interest to the respondent society. Hence, this petition is filed. Having taken note of the factual aspects on record and taking into and as the Lana Council appealing for the petitioner seeks a reasonable period to complete the to pay the principal amount with accrued interest in 4 installments within a period of 8 months from today, the said submission was opposed by the Lana Council appealing for the respondent society. However, taking into consideration the factual aspects that the said loan was sanctioned during 2017 and thereafter on account of the COVID-19 pandemic, I find force in the submission made by the Lana Council appealing for the petitioner that the petitioner has defaulted in making regular payment to the respondent society. In that view of the matter, I'm of the view that if the reasonable period of 8 months is granted to the petitioner hearing to pay the principal with accrued interest within 8 months with 4 regular installment, same would four ಎಷ್ಟು ಬರುತ್ತೆ?
As of today, the calculator
7 lakhs. ಅಲ್ಲಿವರೆಗೆ accrued. That will 4 installments without fail. The said submission was full stop, though this full stop. In order to full stop, taking into consideration the factual aspects that the petition hearing has defaulted, I feel that the petition hearing shall pay the principal amount with accrued interest with 4 regular installment within and complete the entire process exercise and complete the loan account with the interest by 8 months from today. So with this observation, the writ petition is disclosed. Better. 50,000. Amount in deposit society ke kalsmana. We transmitted amount in deposit made by the petition hearing be transmitted to the 4th respondent, 5th respondent society 4. Yes. Yes. Then you have to furnish
They are deposited.
Better, that is better. Withdraw better. Yeah, right, sir. Amount in deposit, full stop. The petitioner, the council appearing for the petitioner, the council appearing for the respondent of 5 society is permitted to withdraw the amount in deposit made by the petitioner. And same be released in favor of the Lana Council in the name of the society. 5th respondent society. Yes. 49. What 49 to who appears? Other council. I know. Maybe taken up on day after tomorrow. You sir copy today to Param Party. Or else you can. You also inform us. It is submitted by Lana Council Sri Vaidi Asha that the Madam Srimati Farah Fatima is appearing on behalf of the respondent university in these matters. All the 4 matters are connected. Maybe connected. Very well. In this petition, accordingly, Lana Council appearing for the petitioner is permitted to serve copy of the writ petition to the Srimati Farah Fatima. This turn urgency is there. When will be? When will be the practice? No, when will be the examinations? Then 14th of Monday or 15th. By the time she will also get instructions better. Well, 14th here, we have some other matters. 15th we will take it. 15th. Yes, sir. Yes. No, now, but it is not listed. Then you have to do one thing. You can move it on 14th. You move the memo on 14th. Anyway, it will be taken up. It will be listed on 15th. All 4 matters will be taken up together. Yes, 6 matters. Same up to 54 same order. Yes. Yes, sir. No. No. That's why I said you oppose the petition. Nothing to be worried. Yes, sir. 57. What is this? Yes, madam. What is this matter? Whether it could be disposed of? Any urgency in the Any urgency in the final hearing matters? 57. 10 matters. No representation on behalf of the petition. List next week. Same order. No, same order. 59, sir. Next week. Next week. Next week. Following week. Yes. List after 2 weeks. Let it be there. List after 2 weeks. No representation. List after 2 weeks.
Serial number 62.
61, sir. 61.
Please.
Honorable Supreme Court. No, Honorable Supreme Court. Not your Supreme Court. No, Honorable Supreme Court. You say like that. Whenever you say mention, you say Honorable Supreme Court, Honorable High Court, Supreme Court, High Court. That's not okay. Honorable Supreme Court. Sorry. Now it's correct. Now you are corrected. It is submitted by the council appealing for the petitioner that this matter be taken up after 4 weeks in view of the pending proceedings before the Honorable Supreme Court. Yes, please stop the programs. 62. No representation is after 2 weeks.
Milord, serial number 62, Milord.
Yes, sir. After 2 weeks, sir.
Senior is suffering from viral fever. Kindly have it after 2
2
weeks.
weeks. 2 weeks, sir.
Please,
Yes, yes.
Maybe taken up. I'm appealing for the petition, my lord. One of the
Next week it may be taken.
2 weeks, man. 2 weeks.
No. 63.
I pay for 2 weeks, man.
Next week on day. Yes.
My lord, I pay for 2 weeks, my lord.
No, he is insisting for
No, it's
taken up today itself, actually.
No, my lord, sorry, some problem, my lord. That's why 2 weeks, my lord.
He is insisting for taken up today itself, sir. That's why.
No,
No, next week, no, let us please.
please, man. Please.
ಆಮೇಲೆ ತಗೋಬಹುದು. Urgency ಇಲ್ಲ. Due to positive time, matter was not reached. List after 2. List after 3 weeks. After 2 weeks, man. No representation on behalf. Yes, madam. No representation on behalf of the petition. List after 2 weeks. Yes. Urgency, yes. 2 weeks. List after 2 weeks. The meanwhile interim order granted earlier. Extended till next 30 years. Then more matter. More matter. Yes, ma'am. $15, madam. You make 15th ಅಲ್ಲಿ ಮೇಡಮ್ಗೆ ಟೈಪ್ ಮಾಡಿದ್ವಿ. ಪ್ರಿನ್ಸಿಪಾಲ್ ಸೆಕ್ರೆಟರಿ ಮೆಡಿಕಲ್ ಅದೊಂದು ವೆರಿ
Court officer, sir. Sir, serial number 60 ಏನಾಯ್ತು ಅಂತ Madam, serial number 60.
Sir, 2 weeks, sir.
2 weeks. Okay, okay, madam. Thank you.
Only 230 matters sustained.
Court officer. Madam Court officer.
Yes, madam.
Madam, serial number 62 adjourn ಆಗಿದ್ಯಾ?
ಹೌದು.
Okay.
ಎಲ್ಲಾ ಮ್ಯಾಟರ್ಸ್ ಅಡ್ಜರ್ನ್ ಆಗಿದೆ ಎಕ್ಸೆಪ್ಟ್ 230 ಮ್ಯಾಟರ್ಸ್.
Okay, thank you.
Yes.
Development of order. Either 158.
Appeal dismissed.
Appearing on behalf of respondent number 4, my lord.
Petition is dismissed as divide of rights.
Grateful.
Yes. No, it is heard. Only cost. File amendment. File amendment. Yes, madam. How much cost has to be? So 2 points means plus 2 lakhs. No, I will permit you to withdraw. Otherwise, if it is on merits, it is a privilege, abuse of process of court proceedings, and I will grant you to withdraw. Otherwise, take instructions. Thought of imposing cost of nearly 10 lakhs. What is the locus standard? That's all. That's all. The final chance I can give you, that's all. Otherwise, hefty cost. Because if you look at I read it also thereafter also. I read it the entire papers also. Felt that is a clear abuse of process of no locus standard at all. And nothing but is filed by the association to protect their individual interest. To protect their individual interest. 48 lakhs. 48 lakhs.
And rent is only 6 rupees.
6 rupees.
Yes, only 6 rupees. And 3 rupees.
Because I've gone through the papers later also. So 48 lakhs rupees is due. Try to get at least 10%. Sorry, 25% now. I know.
Really.
This petition is filed by the association. We have first of all, no locus standard. Now, still they are residing even after retirement by making payment of rent 6 rupees per month. Huh? So, get ready by Pass over, pass. Yes, Mr. Tahir. Rival. This is allowed. Huh? It's allowed. Only thing is, what is your legal right to challenge the rival? I think he has given some judgment, which is that type, please. Have you enclosed, sir? Very well. No, let there be a competition between two schools. And ultimately, the benefit is for the masses, for the students. Correct. So, directed to approach the authority. Directed to approach the authority.
And this is it is been there from 1960. They might have wanted to.
Take a chance in good case. No, what will happen if the rival school will come? Now you are only running. Now in a competition, the 100 meters competition, only you are running. Definitely will win. Now at least one more is there. Now it's strive for better.
No, these students have been transferred to the private school.
Yes. Yes, sir.
All the students who are in aided school
yes.
have been transferred to private school.
Yes. Yes.
And the same way, the minority system has recommended.
One thing what I'm saying, Annexure D dated 28/7/2018. That's correct. We cannot. See in 226. See 226 can be recorded if there is an arbitrary. Can you say that any arbitrary? Tell me now. You said, tell me, sir. This issued by so and so 28/7. It is not contrary to 14 and you know. There is. Take a chance in good petition. No. What ಕೇಳಿದ್ರೆ ಕೊಡ್ತಾ ಇದ್ದೀನಿ. Not now. It's ready. How can you know? So you have seen the everything and all those things. Huh? The last week ಹೇಳ್ಬೇಕಾಯ್ತು. Okay, sir. ಬೇಡ ಬಿಡಿ sir. And a counsel appealing for the petitioner submitted that the petitioner be permitted to withdraw the petition with liberty to approach the competent authority under the provisions of the Karnataka Education Act 1983, which is the efficacious remedy available under the said act, reserving such liberty to the petitioner. The petition is disposed of. Disposed. ಅದು ನಮ್ಮ ಕೈಲಿ ಇಷ್ಟೆಲ್ಲ ಬರ್ಸ್ಬಿಡ್ತಿರಲ್ಲ ನೀವು. No, even in this petition also relating to this is the same thing I have raised this. Because let the authority will look. They are the best one to look. Nandire 72. Yes. Ready ಇದೀವಿ ನಾನಂತೂ. ನಾನು ನೋಡ್ಕೊತೀನಿ. Just facts. Just 1 minute. Who is the petitioner, sir? Who is she? Borrower? Site. Yes. Two? Yes, sir. Annexure A, yes. This property was correct. Next one, sir. So, it was defaulted.
Yes, this loan
Lakhs 80,000. Correct.
There was a default in the repayment.
Yes.
Then this KCC responding to the one, they are initiated proceedings. They will issue notice.
That's 29.
Then notice we have this past investment. We approach the principal government is only
Yes. Yes. Next year, yes, correct. 4,70,90 received on so and so. Has been closed. Correct. What about the case of ledger? Case of ledger, it is closed. It is undisputed.
It is now. These persons that come up with
By KSFC. NA Balaji. Whether it's a party. Very good. Anyway, suit is not maintained. But the 29, 39, 31. So now it is auction purchased by the 3 R3. Yes.
And the suit was only for bad elections where the suit it was that RA. And that RA also on the same.
Is the by virtue of the action was sold in 2006. Petition is 2013.
The nursing case was there. And this other court will be the proposed to get only take action. That's should be. That was the decision taken by
Confirmed by the
this is the
Section 29 has to be exercised only against a defaulting industrial concern, not against that is the law. That is correct.
now their remedy is now over. They have to go for the civil process.
You invoked 29 against the guarantor. That is not correct. No, but you cannot invoke 29 against the surety. This was 2008 or much earlier. Anyway, it is also even before a judgment of the apex court transaction is made. This is 13th March 2018. Yes. Third. So after this judgment, request of the council for a respondent number. Meanwhile, we clarify the direction given at para number 26. Please go to 26. No, sir. We're there. Not against any other person or property. What about the ultimately it said that you cannot invoke 29 against the surety. So anyway, by that time it was auctioned and was cleared. The above loan account has been closed in our books with payment of 4,78,000 ante idi. Yes, sir. By way of GOK means not by interest. One minute. Subjection is there. Objections. These subjections are there. Case of has filed objection. Not even in other objection. Awesome. Just pause. Yes, Shiv Prakash sir. What best could be done? So they have already correct. No. What has happened by the time the Honorable Supreme Court rendered that judgment, by that time sale deed was executed. This time unsettling the R3 is not. Because even otherwise also, even if fraud is given otherwise, what will happen? So firstly, it suffers from delay. Even if take for an example, he has purchased the property in the year 2006, sorry. 21-1-2-1-6. So what has happened? It was almost 17 years back. So, moreover, it,
the proceedings for the default started.
yes, Shiv Prakash, take a chance in next case. At the earliest. I don't want to disturb the R3 right now. That's what I'm feeling. Maybe that there may be chances. I don't know. Whatever you said may be correct or not. That is there's a different aspect. But after 17 years, the person is in position and is running the. Yeah. Let there be a lesson to your family people, not to be a surety for him. Henceforth.
And also, those things that have taken in the image.
I don't find good. Even on delay also it goes. Even otherwise. Even if the Honorable Supreme Court say that, even if there is a merit, delay disentitles relief. AR SCW 2013. At the threshold. I am saying, since you are senior member of the bar, you are to be in this place. That's why. See, unsettling a person, one is there for more than 17 years, sale deed was executed. Then. 6. Yes, sir. Ah.
Then these persons are come up with this little mind of
Yes. Yes, sir. Yes, sir. Iram. No. In your petition, say that election. So she is the Lohit Industries. Then suppression. Then yes. Tomorrow, ನಾಳೆ 2:30 ಅದರಲ್ಲಿ. Tomorrow 3 matters are there. I will take it up to tomorrow later. ನಾಡಿದ್ದು ತಗೊಳ್ಳೋಣ, ನಾಳೆ ಬೇಡ. ನಾಡಿದ್ದು ತಗೊಳ್ಳೋಣ. No, nothing. List on day after tomorrow. Registry is directed to put up the statement of objection filed by the respondent cases. No, let us will see. No, let us will see. Let us will see. Let us will see. Yes, day after tomorrow. 2:30. Past 1 minute. Yes, madam.
Serial number 70.
Yes, madam. Mary's. Good evening. So, ready to pay 10 lakhs. Could 44 lakhs andre, I think we will make it 50%. Maybe. Else I will reserve it better. Reserve on the match. Reserve. Yes, sir. Really. Added for.
Statement of objection.
Malaria. Put it. ಅವ್ರದೇನಾ ಲೋಹಿತ್ ಅವ್ರ ತಾಯಿನ ಇದು. In this writ petition, mute ಮಾಡ್ಬೇಕು.